The EMI and Larrikin case involved a dispute over the copyright of a 2-bar riff from the children's song Kookaburra Sits in the Old Gum Tree, which was held to have been plagiarised in the #1 worldwide hit Down Under by Men at Work. Once the court established that 2 bars from a 4-bar tune did possess the required separate originality to be considered a copyrightable standalone piece of music, the court then looked to see if the alleged contravention concerned a substantial quantitative measure of the original material. The court is not concerned with the length of the original song or the importance that it places in the subsequent music. The more relevant consideration, as applied from Designers Guild, is the context the piece has with the original copyrighted material. As it turns out, only 2 bars from Kookaburra was deemed to be copied and reproduced in the 92-bar song Down Under. The court will then consider how similar the alleged infringing material is to the original. The test is that of a reasonably experienced listener, but not of a layperson, and the judge may be assisted by expert evidence, but will be found to be an error if excessive reliance on that expert is used. The test is then considered against a number of headings. First, the melodic structure and note progression, which are strikingly similar. This point is irrefutable. Then the corresponding themes. Does a children's folk song written for the Girl Guides in the 1930s have an equivalent theme to the lead break from a pub rock band? EMI's case wasn't helped by evidence of Men at Work cheerfully singing the lyrics to Kookaburra live on stage. Then the harmonic structure. Kookaburra is a folk song performed in the round in the key of G. Down Under is a lead riff in B minor. Then the tempo. Both songs are written in the 4/4 tempo, as is almost every other song of the century. Finally, an oral comparison is undertaken, which held that where the ear can recognise the tune, the instrumentation used will be insufficient to exclude liability. In the end, the appeal court unanimously conferred with the trial judge and held that Men at Work did in fact plagiarise the song Kookaburra, and that this use did not fit within one of the fair dealing exceptions of the Copyright Act. By not granting leave, the High Court reiterated the methods of the appeal court in determining their finding. This case has gone on to highlight some of the divisions that the legal profession has with the court of public opinion, specifically the purpose of copyright law. Outside of high technology inventions, is it more concerned with the economic interests of the owners of a tradable commodity, or was it intended to provide protection of an unquantifiable creativity through a limited window of exclusive use? Rather than settling the law so that a judgment of the copying of similar sounding material can be followed in the future cases, the court instead left a number of questions unanswered. Is it reasonable that copyright should remain so restrictive 2 decades after the death of its creator? When does art become the property of the public domain, particularly when it is bequeathed to a charity, in this instance the Girl Guides, and then donated, as it was to the South Australian State Library? What role should a professional music expert play in providing evidence for a test of an objective, ordinary, reasonable listener? And if that test is for a listener, why is the note progression on the page considered? And finally, how can objective license remain unapparent 25 years after the infringement occurred? In his findings, Justice Emmett noted some disquiet about the decision, because he felt that the melody could be considered a tribute to the iconicity of Kookaburra. Perhaps an expansion of the fair dealing section should be considered to include the use of a piece of music in good faith as a tribute and not to gain commercial advantage.